file thing. Oh, I was in the right spot.
You
That's
were.
always nice.
All right.
I think it's a wonderful layout. I think it looks so much cleaner than the having to look through all the.
Oh
It
my
was
gosh.
stupid before.
Yeah, and my whole thing was if you get tired and you're sleepy, just pull it out and read it, and you know, the current one.
Yeah.
Because it was awful.
Yeah.
All right.
Have fun.
Yes.
Fun kids.
Okay, now that's showing.
Are you coming back there? Yeah, I just have to let Ella out to go hide. Were you even here for a long time? Oh, yeah. Yeah, I get here at like 8 when she was there. Her 5-hour mark. Well, I should eat some.
Okay.
Now I'll be back. Be back for you. She's going.
As I said during the sales rally, this is a new law. There's a specific place that you can go right here online, and if you want to read it, it's chapter 18.86, and it talks about agency law. And so some of these changes are now going into effect January 1st. Oh, good. I thought for a second there that I didn't have the right document. So basically, this is a wonderful tool. I thought this was the best thing in the whole training, was this new pamphlet, because it's just easy to read and understand. And this is something that is, if you can do 2 pages, it's certainly a lot better than that 8 or 9 page. And the same thing if they just initial it that they've received it. So if you just make the front page of this just by itself and then have a place where they can initial it, then that can go into your documents. This will be effective January 1st, which is right around the corner, really coming fast. Licensing and supervision of brokers. As I read through this, I realized I really had never, probably at some point, 12 years ago, I might have read that pamphlet, but I thought that this was really good. So to provide services in the state of Washington as a real estate broker, they must be licensed, and they must be licensed with a firm, which also must be licensed. Each real estate firm has a designated broker who's responsible for supervising the brokers licensed with the firm. Some firms have branch managers or managing brokers, which I'm one of. And so what that does is for all of our clients, they're my clients as well as Russ's. Actually, they're Russ's clients, and I'm responsible. So when you talk with me about your client, the principal, then I have the same fiduciary responsibilities that you do. And so it's really important that we understand that and that we get in line. The Department of Licensing is responsible, and when they come and audit, they're going to be looking at what we do and how we do it. In an agency relationship, a broker is referred to as an agent, and the seller, landlord, buyer, tenant is referred to as the principal. For simplicity in this pamphlet, seller includes landlord and buyer includes tenant. I don't know that there's anybody in our firm that deals with leasing and tenants. I'm not sure, but I don't think so. So for sellers, a real estate firm and broker must enter into a written services agreement with the seller to establish an agency relationship. So your listing agreement, which I asked this morning, would we ever do a listing without having one? And no, we would not. The firm will then appoint one or more brokers to be agents of the seller. The firm's designated broker and any managing broker responsible for the supervision of those brokers are also agents of the seller. So this is the major changes on this. I know that because I did all listings and Tom did all buyers, part of his packet, his support packet before he wrote an offer included a buyer's agreement. And so now what's changing is we have to do that before we provide services for them. And so when we get to the form of the non-exclusive agreement, then we'll take a look at that. And for those that don't want to just be exclusively working with you, or you feel uncomfortable asking them to do that, or are there other brokers that you're working with, then it's going to be very important that we have an agreement with them before we show. If we're listing, as I said earlier, we have to have an agreement before you can show the buyer. You have to have an agreement signed by the sellers and the buyers that you can have a limited dual agency rule. So for buyers, a real estate firm and brokers who perform their real estate brokerage services for a buyer establish an agency relationship by performing those services. Remember last week we talked about that one broker that had been working with her buyer for 2 months, and there was the big hoopla with another company. So the implied services that we perform creates the agency. The firm's designated broker and any managing broker responsible for the supervision of that broker are also agents of the buyer. A written service agreement between the buyer and the firm must be entered into before or as soon as reasonably practical after. Okay, that is where that term reasonably practical. That is the most ambiguous. What?
ASAP.
Yeah. A broker begins rendering real estate brokerage services to the buyer. So it's getting closer and closer to the time when we're actually going to physically meet them. You'll want to do a buyer's consultation because you want to know are they at the beginning of their journey? Are they, have they even thought about how they're going to pay for it? Have they gone to a lender? Do they have a lender? Do they understand what that means? Do they understand the escrow process? What is the closing cost going to be? So you want that with your buyer consultation. Anyways, but now it's the law, January 1st, to be able to make sure you have that agreement. Now, this particular one, and Russ is going to come back and he is going to be very clear about this. When we were talking about it before he left, it could be anywhere from anybody in our company under 2 years. He is going to require that if you have a listing and you acquire a buyer, that you refer it to somebody else. Between now and the first of the year, we'll verify that. But it's dual agency is a really interesting, because and I like the way they call it limited dual agency, because you cannot share all the information with either the buyer or the seller, and you can't do anything detrimental to one side or the other. And we have to be very careful about that. So a limited dual agent provides limited representation to both the buyer and the seller in a transaction. Limited dual agency requires the consent of each principal in a written service agreement and may occur: 1, when the buyer and the seller are represented by the same broker; in which case the broker's designated broker and any managing broker responsible for supervision of that broker are also limited dual agents. And then, or two, when the buyer and the seller are represented by different brokers, but in the same firm. So Russ is, if we keep it both sides in-house, he is doing a limited dual agent. And if you ask information from me, then I would be doing that same. And so we would need to have them understand that. So I will know more about what forms specifically have to be signed. But if you have a listing and another broker in our company has a buyer, then they need to be aware that Russ is a limited dual broker. And we'll find out. And that's, I know that on the listing agreement, the new one, there's going to be a place for them to sign. It's a new, they've just taken that paragraph and they've just redone it. So there'll be a place. And I know on the new buyer's agreement, there's a place. So that means that there would need to be two different forms. But also in the past, we've used a form 42 if it was the same person, where it would, on a form 42, you can choose a drop-down buyer and seller, and then by their names you identify which they are. Duration of agency relationship. Once established, an agency relationship continues until the earliest of the following: completion of performance by the broker. And you've heard Russ talk about this before. After closing, you are not their broker because that deal is done. Expiration of the term agreed upon. If you go to a 90 days or 120 days and it goes beyond that, you have to get a new agreement. Termination of the relationship by mutual agreement of the parties. As you know, Russ has been very liberal in that if somebody is really not happy and they want to leave us and go to either another broker or another brokerage, we want them to be happy. Termination of a relationship by notice from either party to the other. However, such termination does not affect the contractual rights of either party. So if you bring a buyer to a seller and then they terminate that listing agreement and then they engage in a sale, then there are some partial rights there on that. Okay. And we'll be dissecting each one of these new forms each week until we make sure that we really get very comfortable with this. I really like when Amanda was in here, when she talked about she was buying real estate in another state, and they literally said, I can't work with you or show you anything unless you sign this. And so let me explain what this is. And that's just all you have to say. And if they're real uncomfortable doing the exclusive, then start out with a non-exclusive. So a written service agreement between the firm and the principal must contain the term or duration of the agreement, name of the brokers appointed to act as an agent for the principal, and the principal here is either the buyer or the seller, whether the agency relationship is exclusive or non-exclusive. So you do have that option to be able to offer them. However, if you've worked with them for some time, you really need to protect yourself and be exclusive. Whether the principal consents to the limited dual agency. So it's really important And then number 5 is the whole thing. The whole reason this came about was because buyers were not advised how the buyer brokerage firm compensation is paid. It was just assumed. The seller does not have to pay it if he does not.
Mhm.
It's not good practice, because if it has a real low commission rate, we are all human. We of course will show it, but we would prefer to write something where we're paid, and that's why it's really important to talk about it. One of the things that we're going to do in the future is we're going to really work out that value proposition, so that by the time we get through, they only want to work with us and they understand our value. The terms of compensation, also in agreement with a buyer, whether the broker agrees to show the property when there's no agreement or offer by any party or firm to pay compensation to the broker's firm, and any other agreements between the parties. So that was when you need a written services agreement. There may be a time, and it may come to this, where the seller just refuses to pay any compensation. You want to make sure that you're covered on that. And there are ways that we can be able to do that. One, we can negotiate with the seller and say that this needs to be a part of the deal, and this is the amount, or the buyer agrees to pay whatever is not covered, etc. And as we go through this, then we'll really get into that. As you know, the broker's duties to all parties. This hasn't changed. This is what we were trained on when we got our license. And it's a great reminder. And it's also good to let our principals, our clients know. We really need to be at that level of reasonable skill and care, and deal and be honest and work in good faith. This is one that is so important. This is written into the law, and that's that all offers are timely presented. Any written notices, any communications from or to either party, that's expected of us. So last week when I talked about when that broker said they were not going to deliver that offer, and that other, the buyer's broker wasn't going to get any commission, this is why we call that a real ethical issue, because it's part of our basic responsibilities. When we go through it, to disclose all existing material facts, remember that if we know that there was a leak in the basement, they put a sump pump in, and there's been no other leaks. I think last week somebody had where the neighbor, their sprinkler that goes like that got kicked, and so it went right into the window and it flooded the neighbor's thing. Well, you disclose that, but it doesn't mean that you have to do additional investigation as a broker. And that is a buyer's due diligence when they're in a situation like that. This last line, a broker does not have any duty to investigate matters that the broker has not agreed to investigate. I think you are working on a property that has a couple of wells, and you have been doing a lot of research to be able to explain to buyers exactly, is it a shared well? Are they private exempt wells, and all of that? And that is something that you took upon yourself, because that helps the sale.
Right.
Yeah.
Yes, we are the listing agent, so
that's an example of when you take it upon yourself, or to make it more understandable. Another might be that if you're selling property and it's listed that it can be TA or tourist accommodation. But we need to be really careful because the county of Chelan is really tough to work with. So there needs to be some, we don't have to go out and get that license, but we do need to be able to, if we're representing a buyer, say, this is something, if that's what you want to do, you have to check this out. Does that make sense? Any money or property received on behalf of the party to be able to account for it, to provide this pamphlet to all parties to whom the broker renders real estate brokerage services. And this is a new addition to any unrepresented party. So if you do if somebody, let's say that one of your listing expires and a buyer comes to you and says, I'd really like to make an offer on that house. Will you write that up? So that as a broker is your responsibility to give them this pamphlet and to explain to them that they are unrepresented and what that means. So they finally put that, maybe I shouldn't say finally. Anyways, they put this into the new document. To disclose in writing who the broker represents and to disclose in writing any terms of compensation offered by a party or a real estate firm to a real estate firm representing another party. So that's why now it's just full disclosure. That's just something that has to happen. A broker's duties to the buyer or seller, depending on who your principal is, to be loyal, no action that adversely affects your principal or your client, to disclose any conflicts of interest. So the moment that you might want to show your listing, it's really important that you let your seller know, I'm going to be showing this, and I need to get your permission that I can do that. To offer for your principal to seek expert advice, and I hope we're really good on that. Even though we have Vanessa in the office, if there's an escrow question, she can really help educate us. But it's really important that we send our clients to the expert. If it's an attorney, if it's if it's an issue with a home, okay, well, let's go get somebody that scopes out that sewer line to the street and make sure that we don't overstep our bounds. The number 4 is the one of the most important things, not to disclose any confidential information, because Tom and I work so close together. There are things like with Majestic Heights that Marsha and Ron have shared with me that I don't tell him, because if I told him, then I would be disclosing confidential information. And sometimes that feels so weird because I want to, but I try not to. Make a good faith and continuous effort to find the property for the buyer or to find a buyer for the seller's property until the principal has entered a contract for the purchase and sale of the property is agreed to and otherwise in writing. I'm sorry for going over this almost word for word, but to me, I think this is the best tool. I love this tool. It's going to be really nice for us when we deal with our principals or our clients. A limited dual agent may not advocate terms favorable to one principal to the detriment of the other. A broker acting as a limited dual agent owes the following duties: to take no action that adversely affects or is detrimental to either of the parties' interests, disclose to both parties any conflict of interest, and you need to get that in in writing, also to when they need to seek expert advice. No confidential information and continuous good faith effort to sell or find a buyer. So that's really a good review for us, because that's what we should be doing. In any real estate transaction, a firm's compensation may be paid by the seller, the buyer, a third party, or by sharing the compensation between firms. To receive compensation from any party, a firm must have a written services agreement. That's it, must. With the party the firm represents, or provide a compensation disclosure to the buyer in a transaction, and this is in relationship to commercial real estate. I've reviewed about 20 commercial deals, and I think myself I've done about 5. So this is something I've never done before. So I need to find out what is that form and make sure that on the commercial deals that we do that. How many units does it have to be above for multifamily for it to be commercial?
4.
More than 4. Yeah, very good, Chris. You get the gold star over there. It must contain the amount the principal agrees to compensate the firm for the broker's services as an agent or a dual agent, the principal's consent, if any terms of such consent, to compensation sharing between the firms and the parties. And all this is saying the principal's consent, if any, in the terms of such consent, compensation by the firm by more than one party. So it's just full disclosure. The last part of this is regarding short sales. I'm not going to go into this, but I believe that if not before the end of the year, by the first of next year, I want to do a contracts class on that. Has anybody ever done a short sale? Have you ever done? So the seller owes more than the house, the value of the house. And like in a downturn right now, that's something I think that we're going to start to see, when they were loaning 95%. So go through this and just understand it, but we're going to go through it because there's a couple of extra steps that we need to do when we're doing it. And approval from the lender is huge. And we will go over that. So what do you think?
Way easier.
A whole lot more straightforward.
People can actually read this.
Yeah, and understand it.
And they won't actually just like their initials on the
Yeah,
top.
I mean, the other one was honestly, like half of it was, or more than half, was like reading a dictionary.
Yeah.
It was like, here's a word, here's the definition. And it's like, why do I care about the definition of this? For a client,
Yeah.
Yeah.
So Marsha, this is just kind of a worksheet, right?
No, this is replacing
New pamphlet.
the pamphlet. Yes.
That'll be nice.
Yes, it
Yeah.
will. That was Sarah from Beyond.
Yes, it was. I'm eating.
All righty. Any questions about that? And we may or may not come back to it again. But I like it. I think it's the best thing that they have done. Okay, so we still have a few minutes, and I would like to go over a couple of hotline questions that I thought is important to know and clarify and just reinforce. So this first one has to do with Form 22A. And the automatic one, if it's not filled in, how many days do they have to apply for a loan? Says 5 days. Sometimes you'll see other brokers will write in 10 because they're choosing between 2 or 3 lenders. And so, but the automatic loan application is 5 days. So the question, if we're aware, so this would be, they're on the seller's side. If we're aware a buyer has not made a loan application and we're past 5 days, is there a form the seller can use to terminate this transaction? Or does this only come into play if the buyer's financing fails? Seems to me the buyer is in violation of the contract and seller should be able to terminate. Okay, so that was the question to the hotline. And the answer is, if those 5 days pass, then the financing contingency is waived. The seller can't terminate it. However, so long as the buyer can close timely, the buyer has the right to purchase the property on the terms of the agreement, regardless of whether the buyer waives the financing contingency or not. So if you go over that, it doesn't automatically go. Some things do terminate, but a 22A, if they don't apply in those 5 days, what that means is they better be able to come, or else the remedy then would be the earnest money.
Right.
If they can't.
Okay, so next thing is coming, that it will be extension of closing, because let's just say they forgot to apply, they need more time to apply, the process takes longer. And then next thing you know, they're applying for extra 2 weeks for closing.
So
That's when you can.
So
terminate it.
Chris brought up a valid point. Then what will happen is that if they took longer, when I do a 22A, or when I talk with somebody about doing it, I just really don't like it when it's any less than 45 days. 60 is preferable. You can always move up the closing date if it goes through, if they're pre-qualified, if they've gone through underwriting, then you could do one in 30 days because the underwriters are waiting for the purchase and sale agreement and the appraisal. But it is up to the seller has to agree to extend it, but this is why it is so important to have a really good, honest, open conversation with the other broker, whether it's in our firm or someplace else, to be able to talk honestly with them. Good clarification, Chris. Thank you. Any other questions on that? I thought this one was interesting because, sometimes when you work with your sellers, you get that really personal relationship, and the older they get, sometimes they may want you to be their power of attorney. So the question is, our firm represents a seller on an active listing. The seller has asked the co-listing broker to be her POA, power of attorney, for signing transaction documents to make it be easier. I can imagine it's probably somebody that's not well, whatever. The listing broker is asking for the co-listing broker be removed from the listing, and B, can the power of attorney for the seller without any issues, because if the broker is affiliated with the firm. I don't know. I do know that one of our brokers was asked to be a power of attorney, but they declined, and they said and they were they were the only listing broker. So the answer is, if a broker holds a power of attorney for a seller, the broker is not providing real estate brokerage services. Instead, the broker stands in the shoes of the seller and owes fiduciary duties to the seller because the broker is not providing these services. That means neither the broker nor the firm will be covered by E&O insurance. So guess what Russ is, if we come to him and say, I love this old couple and they want me to be power of attorney. Under no circumstances should the designated broker allow the broker to hold and act as the power of attorney without first consulting with our attorney and insurance carrier. Yeah, so if that ever comes up, then, and there are so many community advocates that would be great power of attorneys if they don't have any relatives or anybody close by. Okay, any questions on that? Form 35R, there's a couple of things I just want to review. If you have a 20-day inspection contingency, and on day 10, you do your inspection, and the inspector asks for another expert to come in, maybe a roofing expert. And so you ask for 5 more days. Is that at the end of 20 days, or is that at day 10 and 5 days added to that?
I think it's triggered after you ask for the 5 days. So if you ask day 5, then you really just get to your date. Well, it'd be business days, so it's still extended.
Yeah. Yeah, so just remember when you ask for additional inspections and your inspection contingency is not close to being expired, then the new 5 days that the Form 35 or 35F, which the feasibility, now that doesn't reply, the Form 35 dictates, then from that time, then you count forward 5 days. So before you ask for additional, make sure you have somebody lined up and they can do it in that time frame. Okay, so this is a little bit different, but I just wanted to go over that. Buyer's response to the inspection due to the seller per Form 35. Buyer's broker submits a Form 35R to the listing broker. Okay, 2 hours later, the buyer broker submits a new 35R to the listing broker, stated that she sent the first 35R by error and resubmits a new 35R with additional request and tried to enforce Form 65A early occupancy. Okay, so there's a couple of things going on here. So this broker, her question, it's my understanding that in no way at any time can a buyer broker or buyer amend or revise a 35R once it's been submitted to the other party. They would have to wait for the seller and listing broker's response. Also, per the executed purchase and sale agreement on Form 22D, buyer and seller agreed home is being sold as is, and no additional negotiations, including price concessions or repair. In my opinion, the 35R in this instance should have only been used to accept the buyer's inspection results or terminate. What are your thoughts? The buyer can always ask the seller to amend the purchase price. If they get into a home and they say it's as is, and they find out they're going to have to, the plumbing isn't good, the electrical isn't good, they're going to have to do everything, and it's priced comparable to homes in the neighborhood that have good plumbing and good electrical. So the buyer can always ask for concession. It doesn't matter how big or in bold print as is. They can always ask it. The seller can agree, decline, or reject, but the buyer is free to ask for contract modifications. And just because it's said that this is as is, I thought that was really important that we make sure that we understand that the fact that the seller has made the home as is irrelevant. Okay, so now back to the first 35R and then the second 35R. Once the buyer submits a Form 35R seeking concessions, the buyer may not withdraw or revise that request for 3 days based on the terms set forth in Form 35. Seller is entitled to consider the request the buyer first submitted, and then the seller agrees, create a satisfaction of the buyer's inspection contingency. So if you do submit one and then you go, uh-oh, I made a mistake, guess what? They have 3 days, and during that time, let's say they just say they want to, raise the landscaping and just, that's going to be something they can do very easily. So it drains away from the house. If they agree to that, then the inspection contingency is satisfied and they go on to closing. So you have to be really careful when you submit that form. Any questions on that? So there are no oopsie. Alrighty, my favorite topic, Form 17. I'm a listing agent and the Form 17 is uploaded into the supplements. The buyer's agent sends me an offer with a signed last page of Form 17. The buyer signed as received but did not waive. Do I have to have the entire completed Form 17 in my transaction file? Your compliance queen will say yes. Is it my responsibility to make sure the buyer received the entire document? Can the buyers leave the contract on the day before closing by saying they did not receive the entire Form 17, even though they signed the last page? Okay, there's so much in here. Okay. The language that the buyer signed on the final page of the form acknowledges their receipt of the entire form. The buyer should not succeed. Do you notice that Annie said should not succeed in arguing later that they didn't receive the entire form? But they might, and they might succeed. So I go back to, as a listing broker, it is so important to make sure that that Form 17 is fully filled out. So in compliance, what does compliance look at?
Checkbox on every line.
If there's a
Every single
checkbox,
line and asterisks.
yes.
Description.
And if there is an asterisk, yes, then on page 5, there needs to be any kind of a description. Just explain it.
Little checkbox that says if they're residing there.
Yes, I think that's line 13, whether the very first one before they answer a question. Now, the other day I saw Form 17 where the first question is, do you have the legal right to sell this property? And they said no. I think maybe we should send that back and say, I'm sure this must be a mistake. Would you verify with your seller that they have the legal right to sell this property? And as a listing broker, make sure it is full and complete. Okay. Alrighty, this one, this is the last one. And I think that there are some experienced brokers that are going to be working with people that are in the developments that are, the final plat has not been approved and they're selling them under a reservation agreement. I did this with over 100 slips at the Sunset Marina in 2017. And so this whole question is, if we're going to use a reservation agreement, which is a Form 43, what is the whole mechanics of that? If you come up to that situation, please call me, call Russ, call Tom, call me. So the question is, what documents need to be delivered to the reservation holder? Also, do all the anticipated addendum, financing, inspection, etc., need to be included with the reservation? And how should the legal description be referenced? And the builders that have the options on these lots will be completing and signing the listing documents. Is the title report required for the reservation agreement? So there's just a whole bunch about the whole thing and how it's done. When you use a reservation agreement, you need to have a complete Form 43, which is the reservation agreement, and a complete and all the addendums in a purchase and sale agreement. So if it's going to be, they're going to be building a house, then it needs to be a 21 with all the addenda attached to it. It may not be complete because it cannot close until it has a legal description. So that means the final plat has to be approved. The legal description, usually in the plat documents, the surveyor will write out what the legal description for each lot is going to be. A title report is not required. However, if it's still in one big piece, as a listing broker, you should get a title report, and then, or a preliminary title report. And then as soon as the plat is filed, then you go back and then you get the title report for that particular purchase and sale. And this last part is the buyer retains complete control over whether the buyer ultimately enters into the purchase and sale agreement with the seller or not. So until you get like a closing date, or you get, when we did it, we filled those reservation agreements up to a year, wasn't it, Vanessa, in advance?
Yeah.
And we got a deposit, we got a $5,000 deposit that was for the reservation agreement. And then the way the agreement was written up, then at the time that the purchase and sale took effect, that would be that would be converted to part of the earnest money or all of the earnest money, part of the down payment. And so that's how we handled that. The buyer may be able to consider a title issue once the title report is obtained. So if they get there and the title has a bunch of liens and all kinds of stuff, and they just don't want to deal with it, then they certainly, that title report gives them the out on that purchase and sale agreement. So that's something that doesn't come up very often, but I want you just to keep it in the back of your mind. If you work with somebody that has multiple lots, you can work with a reservation agreement. You can also do that with a letter of intent. And I believe that's Form 1 something. And I've done it both ways. And so just give us a call. Any questions on that? And that is it. I hope that has been helpful, that new form.
I have a question, Marsha.
Yes.
A while back, you were talking about the dual agency, and I just want to make sure that I understood you. Did you say that Russ, starting November 1st, will, if you have a listing and a buyer, you need to refer the buyer to another agent?
I need to confirm that, but
Okay.
What we talked about the other day, that when this law goes into effect in January, that if you have a listing and you also bring a buyer, he's going to make the final determination if it needs to be a referral to somebody else, and you still would get a referral fee if you keep it in-house.
Sure.
But that is something to be aware of.
Okay. I just want to make sure I understood. Thank you.
Yep.
Thanks for everything.
All right.
So that might be a killer for a lot of, for people who sell their own listings. I know there's a handful of agents in town that, as a rule, sell all their own listings.
Yeah, and it's really the designated broker's listing, because we're a sub-agent to him. So it is his rule to make. And I think prior to 2 years, unless you've really written a lot of contracts, having a dual agency is hairy. You have to be so careful, and they can always come back and accuse you of being revealing stuff. Anyways, so it is his decision to make. whether that's possible or not.
Have you always, just for you guys as a team, you've had other team members, you wouldn't, you don't put each other, if it's the same person, you have another person on the team be on the other side, correct?
Tom and I do that. All
Yeah.
my listings, I've never sold one of my listings. He's always sold them, or somebody
You
else.
always have another agent
Yes.
on the other
And
side.
I will tell that to the sellers immediately. I mean, that's one of the things I don't ever do. I experienced it from the seller's side where we were selling property on Kodiak, and it was long distance. And so I really got a great rapport. And then it seemed like every phone call was a concession for us. And at the end of it, it just left a bad taste. So that's my personal preference. But there are many brokers that do both sides and do it well. But before you get a couple of years in there, I would really recommend, I'd really recommend that. Oh, that's my office. Tom. It says Shane, but that's my office. Alrighty, everybody have a fabulous day.
Thank you.
Alrighty, bye.
Bye.
Marsha.